Let's start with some of the bigger news recently, the budget, state budget. How does that impact us or engineers?
Well, the budget was passed, albeit almost on time. I know that the coalition we worked with on the budget for purposes of securing highway funding and mass transit and related kinds of facilities like airports, etc.,
Right.
called Rebuild New York Now.
New York Now.
We had the lobby day on March 21st, and you participated, I did, and some other of our members. Mike Elmendorf, who is the president of Rebuild New York Now, and also the New York segment of the ACG, Associate General Contractors Organization, he is quoted as stating that the budget has provided the largest single authorization of capital spending ever in the state for highway transportation, and that's obviously a good thing. It means more roads and bridges. But there is a nuanced answer to the question of whether we secured the parity that we wanted in terms of monies prior to 2007. Monies for downstate in the nature of the MTA were equal to monies for roads and bridges. And we haven't fully analyzed every page of this budget yet, but it's been characterized as moving closer towards securing that parity. So, well, New York has been historically very wedded to moving slowly in changing the options available for project delivery methodologies. And there is authorization going back to 2011 to allow for design build. And now there's a bigger push. I know Massachusetts a number of years ago looked at this issue, and there were a real need for allowing for more flexibility in terms of how these projects can move forward. And one of the big ideas that has worked fairly well in Massachusetts is called construction manager at risk methodology. And our concern from the PE Society is focused on two main considerations, and that is we want to make certain that there's a direct contract with the engineering firm and the owner of the project for any construction manager at risk project. And we also want to ensure that qualifications-based selection is the cornerstone for how the engineering firm or the architectural firm or any of the design services are going to be secured. And so we're continuing to do that. We expect a bill to be introduced before the summer recess, and we anticipate that the bill is more likely to be considered in the 2017 legislature than the current legislature. This issue is focused on the passage of legislation in 2011 that for the first time broadened the ownership ability of parties other than design professionals to own a design firm. And that legislation, which the Society was the original sponsor of this bill, we had taken it back, and this, unfortunately, this process takes forever. I mean, I think our initial effort at doing a poll of our members and then setting up a model to work from was going back to the early 90s, if my memory serves me correctly. And it only was enacted in 2011. It might have been the mid-90s, but anyway, the idea was, can a employee other than a design professional own a part of a design firm? And the answer with this new legislation 2011 is yes, up to just short of 25%.
Right.
And this bill that we're contemplating now, or rather that has been put forward by ACEC as another alternative, would be to broaden that ownership interest, provided that the voting rights for the shares and who would be able to control the decision making remains in the hands of licensees, in the nature that 75% of the management committee an ESOP, which would in this paradigm be the largest shareholder of the company, or the trustees that are in charge of the ESOP, they would have to also be licensees. So the idea being that the judgment call for things that relate to anything to do with the engineering related decisions, even tangentially, would be under the control of licensees, and the more broader business issues that ESOPs are allowed to vote on, for example, whether to merge, whether to liquidate a company, they would be able to be determined by the broader shareholders.
And we'll end up here with the land surveyors legislation that we've been working on for years. Why don't you give us the latest?
I certainly will. This is a issue that's been of concern, and its genesis dates back to the 70s, the early 70s. The legislature had adopted and the governor signed legislation which clearly defined broader delineation between land surveying and professional engineering. Prior to the early 70s, I think it was 71 or 72, a land surveyor could do engineering in what in essence is subdivision work, and an engineer could do land surveying, and there wasn't much of a distinction.
Right.
But there was a real recognition that land surveyors have certain expertise with work that pertains to the definition of a legal boundary, and the work related to essentially title work, which a title insurance company is very familiar with, and title insurance agents are familiar with, and it's a different area of expertise. And the effort was made to define land surveying with respect to the definition of legal boundary survey, and differentiating it from surveying like topographical surveys and other surveys where engineers have the expertise to make them, but they really can't define the legal boundary. And that's normative in the whole country.
Sure.
So this bill that the land surveyors have proposed would allow them to roll back the clock and become engineers in relation to minor subdivisions. And we are vehemently opposed to the bill, but there's a lot of energy on the land surveyors association part and many of their members to try to achieve this change. It benefits the engineers not at all, and so we're going to continue to fight.
Okay. All right, great. All right, Mark, and lastly, there's an issue that came up in New York City that we're looking into. Maybe you could just give a quick update on that one.
Most recently in New York City, we've been concerned about a proposal where the city is putting forward a paradigm where a design professional in designing a project would be compelled to act not only as the designer of the project, but also doing special inspections in terms of certifying that the actual project, the construction of the project, is consistent with code and other criteria that are applicable to the project as built and during the process of building, and essentially having to certify that the building was built in a certain fashion. And we have members that are desirous and today do that kind of work, either for their own projects or for third-party projects. I'm not exactly sure if there's a delineation there, but essentially what we want to achieve is to allow our members that want to participate in both segments of a project to be able to do so, but also for those members that only want to do one segment of a project, we want to make certain that they have that flexibility.
So we want to make it as flexible as possible for engineers.
Well, within reason.
Within reason.
Yeah, and when I say within reason, we have a major problem with special inspections by special inspection agencies that are general business corporations that really aren't authorized to provide that service, and we've been fighting that fight for quite some time as well.
Okay. All right, Mark, thank you for your updates and for all your work. We do appreciate it.
You're very welcome.
And I hope that you enjoyed our first NYSSPE Legislative Brief. We will continue to bring these to you on a monthly basis. We'd love for you to comment either at the bottom of the video or at the bottom of this post and let us know what you think of the brief and if you'd like us to add any other information.
And next time, either Anthony will have a jacket or I will have a tie.
That's right.